Hello, friends! Let's be honest, we've all heard it. You need to go file for divorce right now, meaning yesterday. We've probably heard it on the opposite side too, which is, now wait a minute, you don't want to be the one to make the first move, you don't want to rock the boat. But is there really an advantage of being the petitioner, the one who files first in a divorce case, or is that just a legal urban legend? Kind of reminds me of growing up. One of my favorite movies was Candyman, or when you had the sleepovers and you would say Bloody Mary 5 times to see something spooky happen. I digress. But nevertheless, I have over 24 years of courtroom experience, and in family court cases, I have represented all kinds of people, including the reticent or reluctant spouse who doesn't want to file, as well as the sneaky secret spouse who wants to file and has a master strategy on how they are going to win. So on today's video, we're going to unpack the truth a little bit. Let's talk about the pros and cons of being both the petitioner in a divorce and the respondent in a divorce. And let's talk about how it could affect your case, your finances, and even your parenting plan. So stay tuned for all that. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so first, let's define the players in this drama. The petitioner, that is a person who files for divorce first. The respondent, that is the person who responds after they are served with the petition. That's it. You don't get a medal for filing first in a divorce case. However, it can definitely set the tone and pace of the litigation. Now, let's talk about the pros of being the petitioner in a divorce. Starting with number 1, you have a strategic advantage. As the petitioner, you're holding the steering wheel of the litigation, at least initially. You determine when to file, and you've probably had an opportunity to speak to an attorney, gather financial documents, as well as prepare yourself emotionally. The second possible advantage for petitioners is that they may have a psychological head start. Let's be real. If you've been planning to file and ultimately file for divorce, chances are you are a little bit further ahead emotionally than your spouse. You've already rehearsed and practiced this moment in your head. Probably during that third argument about the thermostat being set too low, or the toilet seat being left up, or the garbage can not being taken out. That prep, that rehearsal, that thought process can really help you, especially in the beginning of the case when decisions need to be made quickly or fast. The third advantage that a petitioner may have is that they get control over the initial pleadings. They get to tell the court their side of the story first. Is that the final word? Not necessarily. But it is the first impression. And sometimes the first impression can stick throughout the entire court proceedings. Next, let's talk about some possible cons facing a petitioner. And the first one has to do about that money. That's right. The petitioner has to pay first, meaning that the petitioner pays the filing fee in order to open the case, which in Florida, it's around $430 as of the taping of this video, and it could possibly set off very costly litigation. Number 2, the petitioner can be perceived as the aggressor in the case. Some judges or mediators, they may read the pleadings or the case docket and perceive the petitioner to be the one who's pushing the divorce forward, especially if the other party was unaware or unprepared for the divorce to be filed. That doesn't necessarily hurt your case though, but it is a subtle dynamic to be aware of. Alright, so on the complete opposite side of the spectrum is the respondent. Well, let's start to talk about some of the pros of being the respondent. The person who's just sitting there trying to have their cup of coffee, or walking outside their yard and looking at their garden, or maybe walking into their office and all of a sudden a process server approaches them and bam! They get served with a petition for dissolution of marriage. After that initial reaction, whether it be jaw-dropping shock, rage, and anger, or whether it be uncontrollable sobbing. They have to dust themselves off and realize that they have time to react, which is one of the biggest pros that respondents have. They have to realize that with this time to react, they usually have about 20 days. In Florida, it's 20 days. In other jurisdictions, it may be different. But they have to realize they're on defense, and that's not necessarily a bad thing. Remember, I'm from Chicago. The best defense that ever played in the NFL is the 1985 Bears. Where I come from, defense wins championships. So in a divorce case, the respondent has to start thinking, how am I going to defend this? We're going to file a motion to dismiss, a motion for more definite statement, or a motion for sanctions. Either way, they have to take the time because they have the time to try to react and see how to respond. The second pro of being the respondent is that they can sit back a little bit and let the petitioner overplay their hand. Sometimes petitioners, they throw boilerplate or big petitions and ask for things that they may not be entitled to. Maybe they're asking for alimony when it's not an alimony case. Maybe they're asking for a one-sided parenting plan when the law doesn't support it in the way that they asked for it in their petition. Or maybe they forgot to add an indispensable party. The respondent could sit back, think about how they're going to respond, and when they finally respond, maybe in comparison to what the petitioner filed, they will look like the more reasonable person. The third and final pro that we'll talk about, at least in this video for respondents, is tee up the counter petition, baby! Boom! What do I mean by that? I mean that when the respondent files their counter petition, they can actually ask for more or greater relief than what the petitioner asked for. For instance, the respondent can ask for partition of the marital real estate. If the petitioner didn't do it, they can ask for one of the properties to be sold. The respondent can also bring in a third-party respondent. Let's say the petitioner had a relative who they bought a house with or invested some money with or has an asset with. Well, if the petitioner conveniently forgot to bring that respondent in or that third party, the respondent can drag them into court, which is always great. What about if there's a family business or a corporation? Did the petitioner conveniently forget to add that corporation to the case for equitable distribution? If they did, the respondent can now bring or drag that corporation or business into the case as well. So respondents, they need to take their time, think about how they're going to hit back, and when they do, they got to hit back hard. I've heard people say before that you never come to family court for free. Now let's talk about some of the cons of being the respondent, and the first one is that the respondents oftentimes are playing catch up. Let's not sugarcoat it. If the respondent didn't see the divorce coming, they are playing catch up and oftentimes in reaction mode. And this could lead to some very rushed decisions, especially if temporary relief motions are filed or set for court, whether it be temporary child support or alimony or parenting plans or custody. This reaction mode can lead to some bad decisions. And I've seen it also where the respondents are shocked. There's case paralysis. They're non-responsive because they're still overwhelmed by the fact that a divorce was filed. And this in turn could hurt their case because it could take them a while to get up to speed and in a mode where they can be effective either in the case or assisting their attorneys. The number 2 con of being a respondent is that respondents, they don't get to choose venue. As long as the service requirements are comported with by the local rules or the rules of the jurisdiction of that state. If the respondent lives in a different county, a different city, or even in a different country, the petitioner picks the battleground state, and this could be huge. This could affect travel, this could affect strategy, and this could even affect which judge sees the case or oversees the case. It can have a huge impact on the children's issues as well. So that's a con that is very significant for respondents. So, in the end, does this really matter? Meaning, does it matter to be the petitioner or the respondent in the case? And here is the truth from someone who has seen thousands of cases in family court. It matters a little bit. What matters more, though, is having a plan, being prepared. Whether the person files first or responds second, the outcome of the case depends on oftentimes the facts of the case, the goals and willingness of each person to compromise, the quality of the legal team, if there is a legal team. The person is representing themselves, then they have that option to do that as well, and how emotionally ready that person is to handle or go through a divorce case. I have seen petitioners get crushed because they were not emotionally ready. I have seen respondents win because when they enter the case or respond, they are the ones that are calm and have clear goals. The title of the person on the case, be it petitioner or respondent, doesn't really matter as much as the preparation of the person. All right, final takeaway before we wrap up this video. Should a person file for divorce first? If they're ready, yes. But if they're still checking their phones and their text messages and their emails, debating upon whether or not it's over, then probably not. You should go to marriage counseling or talk to one of your church elders or someone at the synagogue. Because the courtroom, especially divorce court, is not therapy. And divorce filings, they are not, and I repeat, they are not romantic gestures. All right, that's a wrap. And if this video helped clarify that whole file now or wait till later thing, and you know someone who is currently Googling how to divorce without drama, send them this video and have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Drop a comment below and subscribe to the Divorce Broadcast. We'll see you again soon. Thank you.